about what the Consumer Financial Protection Bureau has been up to, and they've been very busy lately. In the last 2 weeks, they've probably issued 6 or 7 new regulations. As you recall, the Consumer Financial Protection Bureau was established by the Dodd-Frank Act that came out a couple of years ago. Their whole purpose is to protect the consumers and as a result of all of the issues with mortgage lending. And today we're going to be talking about the ability to repay in the qualified mortgage rule. The loan originator compensation rule. Loan originator compensation rule has that seller financing component that we've been watching for the last 2 years. So we're going to talk about that today. Appraisals for higher price mortgage loans, mortgage servicing rules, high cost mortgage and home ownership counseling, and disclosure and delivery requirements for copies of appraisals. We're going to also talk about a few of the provisions, real estate provisions in the fiscal cliff bill, things that were saved at the last minute, and then some legislative and regulatory issues that we're not covering in the prior slides. In state law, we're going to talk about liquid waste, but that's going to be short and sweet. And I'll give you a quick title insurance, no pun intended, title insurance update, and I want to touch on foreign broker law for a moment, because this comes up quite frequently on the hotline. I probably will not have a chance to get to these forms, but I wanted to let you know that we have released new and revised forms both last year and just recently. And how many of you guys have looked at the videos on those forms? Just a few. If you go to the Ranm website, we created about 5 or 6 videos on new Ranm forms that we released recently, telling you what the changes were and how you would use the new forms. So I encourage you guys to do that if you haven't done it already. I'm just going to briefly touch on those at the end of the presentation. All right, so ability to repay. This becomes effective next year. Most of these regulations that were issued will become effective in January of 2014. So as you recall, the Dodd-Frank Act required creditors to make a good faith determination that the borrower could actually repay the loan. You know, it's hard to believe we actually had to codify that, but it's now in law that the lender has to do that. So it covers consumer credit transactions secured by a dwelling, and it excludes open-end credit plans, timeshares, reverse mortgages, and temporary loans. It doesn't impose specific underwriting standards on the lenders, but it does ask them to look at 8 factors, and these are the factors: current or expected income and assets, employment status, monthly payments of covered loan, monthly payments on any simultaneous loans, monthly payments for the mortgage-related obligations, debt obligations, alimony, child support, to do a debt-to-income ratio, and their credit history. So these are the things that the lenders are supposed to be looking at now before they make a loan. And they have, this is law now, so it's not an option. The rules encourage the creditors also to try to get borrowers who are in riskier loans, higher interest loans, loans that might have balloon payments or things that they consider to be riskier loans, try to get them into standardized loans with fixed rates for at least the first 5 years if it reduces the borrower's payments. So in doing this ability to repay analysis, the lenders can make what's called a qualified mortgage. And if they make a qualified mortgage, then it is presumed that they've done their due diligence and their ability to repay analysis if it is a qualified mortgage. So what is a qualified mortgage? First of all, for regular loans, regular standard loans, there is this safe harbor for qualified mortgages, meaning that if you've made a qualified mortgage on a standardized loan, then you are presumed to have complied with the law, period. If you make a qualified mortgage on a high-price loan, there's a presumption that you have complied with the law. But the consumer, the borrower, can actually rebut that consumption. They can actually say, no, maybe not. We'll talk about that in a few minutes. So what are the QM requirements? Well, they prohibit negative amortization, interest-only payments, balloon payments, terms that exceed 30 years, no doc loans, and loans where fees and points are paid by consumer exceed 3% of the loan total. So I mean, what this means practically, these are the kind of loans we're going to be seeing now. Everybody's going to be making these qualified mortgages because because they want to know that they've, under the law, that they've complied with all the requirements. Like I said, there's a general underwriting criteria looking at various factors. It requires that monthly payments be calculated based on the highest payment that will apply in the first 5 years of the loan. So if those increase, they're going to take that fourth year payment, if those are higher than the first year payment, in analyzing whether or not it meets this criteria. For the safe harbor, consumers have total debt, which include their mortgage to income ratio, and that's before taxes, of less than 43%, equal to or less than 43%. And that gives you the safe harbor. Remember, safe harbor again means that you comply with the rule. You've met all the criteria, you've complied with the rule completely. There's no way anybody can rebut that, right? If you meet all of the other criteria of the qualified mortgage, but the debt to income ratio is actually over 43%, then it is a presumption you've qualified for under the rule, but that's a rebuttable presumption. So the consumer could come back and say, well, no, because my income was over, my debt to income ratio was over 43%, I really didn't qualify for this. And we'll talk about the borrower's remedies in a minute, but that's the difference between the safe harbor and the rebuttable presumption. On high-priced qualified mortgages, where the annual percentage rate exceeds 1.5 percentage points, for first loans 3.5 percentage points, on second liens, that has a rebuttable presumption, and there's no safe harbor for those type loans. To rebut the presumption, the consumer has to prove that the creditor did not, in fact, make a reasonable and good faith determination of the consumer's repayment ability at the time of consummation. And they have to do that by showing that the consumer's income and debt obligations at the time of the origination would leave the consumer with insufficient residual income. That's how they rebut the presumption. When we talk about rebuttable presumption, that's how the consumer does that. It also establishes a second temporary category of loans that's going to be phased out over the next 7 years. And under this temporary category of QMs, you have to satisfy the following QM requirements: no negative amortization, balloon payments, etc. Points and fees can't exceed the allowable threshold of 3%. The loan may not exceed 30 years. But you don't have to meet the 43% ratio. But it does have to be eligible for purchase or guarantee or insurance through one of these organizations. And like I said, this is only going to be around for the next 7 years, and they're planning on phasing this one out.
Oh.
They also have a new set of rules for rural areas, because they recognize those are harder to finance. And so they have this rural balloon payment QM for underserved areas. And the Consumer Financial Protection Bureau is going to issue a list every year. So this is going to change every year for what they determine to be rural areas that qualify. The term of those loans can be at least 5 years, fixed interest rate, meet the basic underwriting requirements. They want you to consider, the lenders to consider a debt to income ratio, but it's not tied to the 43% requirement. When the creditor makes a non-QM loan and does not meet an ability to repay requirement, what happens? So they don't make these loans we've been talking about. While the creditor and subsequent assignees are subject to civil liability under TILA, so the government can go after them. It provides the borrower with a defense to foreclosure. So if the lender makes one of the loans that doesn't fall into the ability to repay, and they subsequently have to foreclose on that loan, the borrower can actually use the fact that the lender didn't do the ability to pay analysis correctly to use that as a defense in a foreclosure action. It provides the borrower with a claim to actual damages, so they can actually sue the lender for making them a loan that they couldn't repay. And it also provides special statutory damages for violation, and that in the amount equal to the sum of all finance charges and fees paid by the consumer. So that's a lot of penalties for not making these type of loans. So like I said, these are the criteria we're going to be dealing with going forward. The statute of limitations on this for civil action, so if a borrower wants to bring a lawsuit against a lender for making a loan they couldn't repay, that's 3 years from the time that the loan is taken. But the defense to the foreclosure action goes on forever and ever. So no matter when that happens, even with 28 years down the road on a 30-year mortgage, the borrower can bring up the fact that there was no proper analysis done 28 years ago on their ability to repay. The Consumer Financial Protection Bureau is seeking further comment on a few issues. They're trying to decide whether it's appropriate to exempt designated nonprofit lenders, home ownership stabilization programs, or certain federal agencies from the ability to repay requirements because they have their own underwriting criteria. So they're still taking comments on that issue. They're also seeking comments on whether or not they should create a new category of qualified mortgages similar to the ones they have for the rural balloon payments, for loans without balloon payment features that are originated and held onto by small creditors that aren't sold on the secondary market. And they're also trying to decide whether they increase the threshold for rebuttable presumption QMs for both rural balloon payments and the new small portfolio that they're talking about. So if you guys have an opinion about any of that, you can go to their website and make comments. Has anybody done that? I mean, other than Mr. Tom over there in the corner. Has anybody else gone to the Consumer Financial Protection Bureau website and made comments on any of these? It's Consumer Financial, it's the abbreviation.gov, and you can go there and you can read about all the regulations, and they've created a website that is supposed to be very user-friendly for the consumers, so you can find things easily, and they give you an analysis of all of these bills from that you can provide to a consumer. What does this mean to me as a consumer? So it's written in layperson's language, and, not overly complicated. Those provisions are not overly complicated, created for the consumer. So if you haven't visited their website, you might want to do that. I mean, that's where all the information is, and they've done a pretty good job with the website. Loan originator compensation. Okay, again, this is the issue with seller financing that we've been talking about. There was also a component regarding whether or not realtors were going to be swept up into this definition of loan originator. So those are the two questions that we're going to talk about today. I'd like to say I'm going to answer all of your questions, but that's not going to happen, and I apologize. But the document that was released, and it was released on Sunday, is 514 pages long. I really wish it had come out about a month ago, so I would have some clarity. I mean, I got through to the extent that I could, but there are so many questions. You would think in 514 pages they could actually answer every question. Really, what else could you want to know after that? But it's so convoluted and confusing. NAR is taking a look at it. They haven't been willing to make any statement about it yet as to what it means. I've taken a look at it. Our resident expert on seller financing, Ranm, with Security Escrow, and his attorneys are taking a look at it. So between all of us, we're trying to figure out what this document means. So I don't have answers for everything today, but I think we'll talk about some of the issues because you're going to hear the buzz out there because it has been released. And you're going to have to stay tuned for the rest of the answers. Look to our website as soon as we have some answers to some of these questions we're waiting on. We'll certainly get that to you.